So this is my judgment. This is a case of summary dismissal of the claimant from the employment of the defendant, which was commenced by way of complaint and other accompanying processes filed on the 18th of November 2015, wherein the claimant asks for certain reliefs as set out in a statement of facts. The defendant often been served with the originating processes, filed its memorandum of appearance and statement of defense with leave of court. Claimant thereafter filed her amended reply to the statement of defense on 18th of June 2021. Case of the claimant. From the pleaded fact filed by the claimant, she was employed by the defendant on 30th of July 2001 and rose through the ranks from the position of higher executive officer to accounts on grade level 08 to become an assistant chief accountant on grade level 13 step 08. That she was confirmed as permanent and pensionable staff and has been highly dedicated in effectively discharging her responsibility to the defendant all through her career. As a recognition of her continuous dedication to duty and stellar performance, she was honored with double promotion sometime in 2007. According to the claimant, her performance was regularly appraised and that she consistently emerged with excellent rating by her superiors in almost all the parameters. That on 29th of October 2013, an approval was granted to the claimant to proceed on a 30 days annual leave, which was to commence from 1st of November 2013 and expire on the 30th of November 2013. But she was informed by the Director of Finance and Accounts that the leave would be deferred in accordance with the defendant's conditions of service. That the claimant on the 11th of November 2014 received a deployment letter but concluded her handover exercise on 17th of November 2014. The claimant again on 11th of November 2014 requested her 2013 annual leave to be deferred with effect from 18th of November 2014. However, she received a message from the General Manager of Finance that she had some letters to colleagues, which turned out to be a backdated query alleging that she absented from work, which she answered. That when a letter of 11th of November 2013 was returned to her, she discovered to her chagrin that the DAF and General Manager, GMF, minuted negatively on her request to proceed on her 2013 leave, contrary to the assurances and encouragement given to her. It was also advised by the claimant that she was advised by her GM Finance to go for a 2014 annual leave, which commenced on the 19th of which commenced on the 9th of December 2014 and was to expire on the 9th of January 2015, but the said leave was cut short because of an earlier scheduled official assignment to Israel, which she embarked upon at the instance of the Minister of Aviation from 29th of December 2014 to 10th of January 2015. Claimant stated that when she returned from her official assignment on the 10th of January 2015 and reported office on the 12th of January 2015, she was given another query backdated to 12/12/2014, which she responded. That she was invited to appear before a disciplinary committee but was not given fair hearing. And to her surprise, she received a letter from the defendant purporting to summarily dismiss her from the service of the defendant. Based on the above pleaded facts, the claimant in a statement of fact asked for the following reliefs against the defendant. Number one, a declaration that the claimant's employment enjoys statutory protection. Number two, a declaration that the summary dismissal of the claimant was wrongful and ought to be set aside. Number three, an order setting aside the summary dismissal of the claimant by the defendant. Number four, an order reinstating the claimant to the services of the defendant. Number five, an order mandating the defendant to pay to the claimant forthwith all the arrears of salary or remuneration and all other entitlements that she would ordinarily be entitled to were it not for the summary dismissal. Number six, an order mandating the defendant to pay to the claimant forthwith the sum of 666,000 naira, being the claimant remuneration for January and February 2015, unlawfully withheld by the defendant. Number seven, the cost of the action in the sum of 2 million naira. Case of the defendant. The defendant's case, on the other hand, is that on the 11th of November 2014, the claimant was part of a redeployment exercise involving some staff members. And while the others complied, the claimant openly protested her new posting and appealed directly to the Director General, violating established lines of authority and the staff conditions of service. That although she handed over her responsibility on the 17th of that although she handed over her responsibility on the 17th of November 2014, but she failed to report to her new unit as instructed. Instead, she took unauthorized leave, claiming it was her 2013 and 2014 annual leave, and absented herself from work without approval. According to the defendant, the claimant's 2013 annual leave was never deferred by the defendant as her request was not granted. That the claimant, therefore, was never on leave as at 3rd of December 2014 on the approval of the defendant. That the claimant, having not been seen at her new duty post, was issued with a query on the 27th of November 2014. The claimant was thereafter charged for abandonment of duty post and absence from duty without leave approval, which are classified as serious misconduct. That as a result of the claimant's continued absence from duty without leave approval, coupled with the unsatisfactory response to the HR's query, the management on 20th of January 2015 directed that the claimant's salary be stopped pending the termination of her case. According to the defendant, the claimant was invited to appear before a central disciplinary committee, and she was duly informed of the case against her. That she was afforded every opportunity to defend herself before the CDC, but the committee considered her defense unsatisfactory, and she was accordingly summarily dismissed from the service of the defendant on 27th of August 2015 based on the allegation of absence from duty without leave approval and abandonment of duty post, which had been investigated and established. The defendant also contended that the claimant's suit is premature as she did not exhaust all administrative remedies available to her before instituting this action. That the claimant did not appeal to the supervising ministry before bringing this action in contravention of the condition of service, and she did not also exhaust the time limit for appeal before prematurely instituting this action. This matter was assigned to me. Maybe Mr. Paul, you should mute yourself. It's like from the background, somebody is trial. This matter was assigned to me on the 17th of February 2021 upon the transfer of His Lordship Honorable Justice Asian. But trial commenced on the 9th of March 2021, wherein the claimant, in trying to prove her case, testified as CW1 by adopting her witness statement on oath dated 18th November 2015, and 14th December 2017, respectively. However, on the 9th of July 2021, claimant applied to amend her reply to a statement of defense and to reopen her case, which application was granted. Then on 29th of November 2021, CW1 adopted a further statement on oath dated 28th of June 2021. The following documents were tendered by the claimant as exhibits. That is exhibit AA1 up to AA 58 A to F. CW was then cross-examined by the learned counsel to the defendant on 29th November 2021 and 21st of February 2022, respectively. CW1 was re-examined and the case of the claimant was then closed. Defendant opened his case on 12th of October 2022 by calling his sole witness, Kennedy Igo, who adopted his witness statement on oath dated 21st November 2016 and tendered the following documents as exhibits. Exhibits NICA 1 to exhibit NICA 27. DW1 was then cross-examined by the learned counsel to the claimant on the same date and was then re-examined and discharged, and the case of the defendant was closed and the matter was adjourned for adoption of final written addresses. Defendant's final written addresses, which is dated the 3rd of February 2023, was filed on the 8th of February 2023, wherein two issues for the termination were raised to it. Question 1. Whether the action of the claimant is not premature, where the internal procedures for resolution of issues have not been exhausted by the claimant before resorting to external adjudication in contravention of Chapter 4.8.1 and 4.8.2 of the Defendant's Staff Conditions of Service. Answer. The answer to the above question is that his suit is premature and ought to be dismissed. Question 2. Having regard to the evidence laid by the parties, whether the claimant is entitled to a reliefs. Answer. The answer to the above question is that the claimant is not entitled to relief sought on court. Counsel for the defendant in his written address at the outset challenged the admissibility of exhibit AA N12 because there is no endorsement as to receipt by the defendant, and that exhibit 13, 35, and 36 are public documents, but we are not so certified. That exhibit 33 and 37 are inadmissible because they are not made in the language of the court. Defendant also attacked exhibit 14 and all the e-tickets and emails for not complying with Section 84 of the Evidence Act. Issue 1. Learned counsel submitted on issue 1 that the defendant's staff conditions of service is a document binding on all the parties, and exhaustion of domestic remedies as prescribed by the condition of service is a precondition to the institution of this suit. They submitted also that where an action is premature, the court lacks jurisdiction to adjudicate on it. Such in the case of University of Ilorin and Oluwadare. Counsel also submitted that it is not in dispute that the claimant did not appeal to the supervisory ministry. Therefore, this court lacks the jurisdiction to entertain this suit. Counsel referred to the case of L.O., Oweseni, and Joshua, and contended that where an aggrieved party has not resorted to the remedies statutorily available to him on the infringement of his alleged right by the prescribed authority, such a party has therefore not exhausted the remedies available to him, and has in consequence not satisfied the preconditions for access to court. Issue 2, learned counsel stated that in a claim for wrongful dismissal of an employee, such as in the instance case, the law is stated that an employee who complains that his appointment has been wrongfully terminated must found his claim on the contract of service and show by credible evidence in what manner the wrong was done. He must plead and prove the contract of service, which is the bedrock of his case. It is not in principle for the employer who is a defendant to prove that the termination was wrongful. Citing the case of Nigerian Gas Company Limited and Judicial. See the submission of counsel that the claimant has failed to prove her case and the law is settled beyond peradventure that averments in pleadings on which no evidence is adduced are deemed abundant. Citing the case of Light Industry and Chinekwe, Olariwaju and Bamiboye, that except by mere averments, the claimant did not lead any shred of evidence to prove that her 2013 annual leave was deferred. That the claimant did not also lead evidence to prove that her 2014 annual leave was approved and conveyed to her. Counsel referred to Chapter 10.2 of Exhibits NICA 2. Counsel argued that the claimant admitted under cross-examination that any annual leave granted by the defendant shall be exhausted within the calendar year in which such leave is earned, or not later than 1st February of the following year, as stated in Chapter 10.2 of Exhibit AA N24. Now, the claimant made heavy weather of the fact that management deferred her 2013 leave. However, Exhibit 9 clearly reveals that it is the same management that declined her request to commence the said leave. The claimant having not placed any material evidence before the Honorable Court to show that a 2013 annual leave was indeed deferred by the defendant, it therefore means that the said 2013 annual leave is deemed forfeited as at 1st February 2014, and her absence from duty without approval was punishable by summary dismissal in accordance with Section 4.7.7 7E of Exhibit 2. Ghana Council argued on the issue of composition of a Central Disciplinary Committee that the claimant did not tender any document to back up her assertion that she was a member of ATSAN. But under cross-examination, the claimant admitted that as a body known as the Joint Action Committee, comprising representatives of all the unions in the defendant's organization, and admitted also that a representative of the JAC was a member of the committee. It therefore goes to say that the claimant's union was duly represented. Claimant's final written address. Claimant's final written address is dated 6th of March 2023, but filed on 7th of March 2023, wherein two issues for the termination were raised. Number one, whether dismissal of the claimant accords with her contract of employment and the civil service rules. Whether the dismissal of the claimant accords with her contract of employment and the civil service rules. Number two, whether the claimant is entitled to all her leaves in this suit. A, reinstatement of the claimant. B, payment of all the arrears of salary. C, payment of the claimant's salaries for the month of January and February. D, promotions. E, award of damages. And C, the cost of 2 million naira only. The counsel for the claimant argued on the objection to the admissibility of some of the claimant's documents that Exhibit 12 was confirmed by the defendant in his statement of defense, and notice was given to the defendant to produce. That notice was also given in respect of Exhibit 13. Claimant also argued that Exhibit 36 is a private document and therefore does not need any certification, citing the case of IGP and Bello. It's also the argument of counsel that Exhibit 3 was acknowledged in the defendant's defense, and Exhibit 37 was not wholly written in non-official language. For the computer-generated evidence, it was argued that proper oral foundation was laid by the claimant, and therefore there was no need for certificate of compliance. Counsel started a case of Stanbic IBTC PLC, a long-term global capital limited, where a computer-generated evidence is not in control of a party, it cannot be required to produce a certificate under Section 84 of the Evidence Act. Counsel contended on non-exhaustion of a condition precedent that it only applies to employees who have been suspended and are still in the employment of the defendant. Counsel cited Section 6 of the 1999 Constitution as amended. Counsel submitted on issue 1 that dismissal of the claimant violated her contract of employment and the civil service rules, that the claimant did not absent herself from work without leave, that the claimant in paragraph 20 of her additional witness statement on all stated that she was granted annual leave from 1st November 2013 to 30 November 2013 on the 29th of October 2013, but she could not proceed on the leave due to reconciliation of accounts and proposed official trip to Netherlands, and consequently the leave was deferred. Counsel also referred to paragraph 20 of the claimant's additional statement on oath. Counsel submitted further that the claimant did not receive any letter of disapproval to her request to proceed on a deferred leave as communicated in her memo. Then counsel stated that the claimant in paragraph 20 of her additional statement on oath told the court that when she was issued the query, she took it to the Director Finance and Account and was told by him to apply for a 2014 leave, which was calculated from 9th of December 2014 to 9th of January 2015. That the claimant's annual leave was disrupted by official trip to Israel along with some NCAA staff. That the defendant sent the claimant's ticket to Israel through the protocol unit via email. Therefore, the amendment in paragraph 39 of the statement of defense is not sustainable, as the defendant's mail register confirmed dispatch of the request for 2014 leave, and that the claimant responded to the query issued to her. The submission of counsel on the issue of double punishment, that the claimant in paragraph 40 of her statement of facts and the defendant amendment in paragraph 41 of her statement of defense, the reduction of salary during the period of unapproved absence from work by employees of NECA, according to a policy expressed by the claimant in paragraph 20 of her witness statement on oath. The defendant's sole witness under cross-examination told the court that Mrs. Fasuji Abimbola, a former employee of the defendant who absconded from work, resigned from the service of the defendant. It was thus argued that it is clear that Mrs. Abimbola was never dismissed for abandonment of duty for about 4 months, but it's only her salary for that period that was suspended. It was submitted that the actions of the defendant for taking away the 2-month salary of the claimant as reimbursement for 11 days on alleged unofficial absence is high-handed and amounts to double punishment for the claimant. Counsel contended that the evidence before the court indicates that the claimant's head of department approved the deferment of her 2013 annual leave, and assuming without considering that the claimant exceeded her leave days, the punishment pursuant to the handbook at page 39, at page 59, paragraph 10.12 is forfeiture of salary for the period of absence. The provision of the handbook which subjected the claimant to further disciplinary action after deduction from salary for the alleged period of unauthorized absence amounts to double punishment, and is therefore inconsistent with the provision of section 36D of the 1999 Constitution, which frowns at double punishment, and therefore, to the extent of that inconsistency, null and void. Where the claimant was a member of ATSAN, that paragraph 4.5 at page 30 of the handbook under subhead disciplinary committee provides thus, and I quote, there shall be a central disciplinary committee comprising representatives of all the directorates, the legal department, and the representatives of the unions to which the affected staff belong, unquote. The submission of counsel that the claimant was never a member of JAC, and representation of JAC in the disciplinary committee clearly shows that the disciplinary committee was not properly constituted, and the decision reached, including recommending for dismissal of the claimant, is null and void, because you cannot put something on nothing and expect you to stand. Citing McFoy and UAC, the claimant pleaded her pay slip Exhibit 18, which shows deduction of union due of 1,891 naira for the month of July 2015 to ATSAN. There's no payment to JAC that purportedly represented the claimant in the disciplinary committee, citing the case of Mr. Valentine Ikechukwu and Union Bank of Nigeria, the judgment of which was delivered on 12th of July 2016, while the court held that payment of union dues is an incidence of union membership. Removal for general inefficiency. The submission of counsel that there was no warning letter issued to the claimant and that the alleged non-dedication to duty ascribed to the claimant is an afterthought and not supported by evidence. That there was no warning letter issued to the claimant for non-performance. Order for reinstatement and payment of outstanding salaries and other entitlements. Counsel argued issue 2A and B together and stated that employment is closed with a true flavor and the defendant in a statement of defense did not controvert the element but mere denial. It is tried that mere denial is not enough and is clearly indicates admission. That is the law that facts admitted require no proof, citing Ogolo and Ibarra, that the claimant averred that he was in the employment of the defendant that is under the control of the Federal Ministry of Aviation and thus regulated by the Federal Civil Service rules. It is submitted that the court should find that the employment of the claimant is one with a true flavor, and the proper order to make should be reinstatement and payment of the arrears of salaries and other entitlements. Payment of the claimant's remuneration for January and February. Counsel submitted that the claimant in paragraphs 40 and 41 of a statement of fact about that the defendant is in arrears of 660,000 naira being her salaries for the months of January and February 2015 in the above sum. The defendant in paragraph 40 of a statement of defense about that the claimant absented herself from duty without leave from 18th of November 2014 to 11th of January 2015. The defendant also confused the situation in the same paragraph that claimant reported to the salary unit on 26th of January 2015. It was submitted thus that there was holding of the claimant's salary for the month of January and February 2015 violates her contract of employment. It was denial of promotion. It was argued that the claimant who was on grade level 12 as at 2009 should have been on grade levels 13 and 16 as at 2020 if her employment was not put to an end by the defendant through dismissal. The denial of the promotion is an unfair labor practice. Counsel referred to the case of Abdurrahman Mariam and University of Ilorin, where this court held that if the court finds that denial of promotion was vindicative and or malified, or that the employee was victimized, then the employee should get a verdict. Counsel therefore stated that denial of promotion to the claimant was in bad faith. Award of damages. The submission of counsel that the National Industrial Code of Nigeria has taken a different approach to the issue of award of damages and compensation to an employee wrongfully dismissed or terminated. Citing Section 19D of the NICN Act, which empowers this court to make an award of compensation or damages in any matter that the court has jurisdiction. That's also cited the case of Sahara Energy Resources Limited and Oyebola. Cost of suit. Counsel submitted that the claimant is entitled to cost of this action and urged the court to grant all her reliefs. Court's opinion. I have studied the pleadings of the parties and the evidence adduced, as well as the submission of the learned counsel for the parties. Having also considered the issue submitted by the parties, I will address two issues for determination, which I think will adequately take care of all the issues and sub-issues submitted by the parties. The issues are, number one, whether the action of the claimant is premature. Number two, whether the claimant is entitled to the relief sought. To the contention of the defendant on issue one, that by the provision of sections 4.8.1 and 4.8.2 of the defendant's condition of service, the action of the claimant is premature because the internal procedures have not been exhausted by the claimant before instituting this action. It was said by the Court of Appeal in the case of Onwanko and Nigerian Army, while setting a different precedent in the interpretation of Section 178 of the Armed Forces Act, that a compulsorily retired Army officer is not bound by the provisions of the said section, thereby not bound to exhaust the internal mechanisms. The above decision has implication for the case at hand, particularly regarding the defendant's argument that the claimant failed to exhaust the internal mechanism before instituting this action. However, it is crucial to note that the claimant had already been dismissed by the defendant and should not therefore be bound by the provisions of sections 4.8.1 and 4.8.2 of the defendant's condition of service. Section 4.8.1 and 4.8.2 provide as follows: right of appeal. Members of staff have the right to appeal to the next level of authority up to the Director General or the board, as the case may be, against any disciplinary action meted out to them. Full access to all documents relevant to staff's petition/appeal should be allowed. When an officer remains dissatisfied with the outcome of the resolution, he or she reserves the right to channel the appeal or grievances to the following in the arranged order as the case may be. Number 1, governing body. Number 2, supervising ministry. Number 3, the office of the head of civil service of the Federation. The time limit for appeal. The time limit allowed for an appeal shall be 6 months exclusive of Saturdays, Sundays, and statutory holidays. That's 180 days on court. Section 4.7.7 of Exhibit 22 also provides as follows, and I quote, an employee dismissed for misconduct shall not be entitled to leave, accrued leave pay, traveling expenses, or severance benefits, and shall vacate the authority's quarters within 48 hours of his dismissal and hand over property of the authority in his custody to his head of department, unquote. From the above, I wonder how a dismissed staff who is required to vacate his official quarters within 48 hours and hand over the defendant's property will still be expected to appeal any decision against his dismissal. By Section 6 of the 1999 Constitution, judicial powers vested in the court shall extend to all matters between persons or between government or authority, and to any person in Nigeria, and to all actions and proceedings relating thereto, for the termination of any question as to the civil rights and obligations of that person. See Section 6 sub 6b of the 1999 Constitution. In any event, the defendant dismissed the claimant on the 27th day of August 2015, and she wrote an appeal later dated 9th of September 2015, but served on the 21st September 2015, well within the time limit, on the Minister of Aviation, Director General, Permanent Secretary, Minister of Aviation, and Head of Service. However, the condition of the defendant is that the appeal has to first be written to the governing board, then to the Honorable Minister of Aviation, and subsequently to the Head of Service. To me, this issue does not even arise at all. It is trivial and ought to be dismissed, and I so do. Given the circumstance, it's reasonable to argue that the claimant's right to institute this action cannot be taken away by the provisions of Section 4.8.1 of the defendant's condition of service. Considering the above, therefore, it is pertinent to assume jurisdiction and hear the case on its merit, resolving issue 1 in favor of the claimant against the defendant. On the admissibility of the claimant's document attacked by the defendant, I've critically considered the objection of learned counsel for the defendant. Exhibit 12, which was attacked by the defendant because there is no acknowledgement, was not only pleaded and front-loaded by the defendant, but was tendered by the defendant itself as exhibits NICA 4A to C. Exhibit 35 was objected to on the ground that it is not certified being a public document. But the exhibit is in its original form and does not need to be certified, and I so hold. The defendant has also alleged alleged that Exhibit 33 and 37 are inadmissible because they are not written in the language of the court. However, I've taken a look again and again at the said documents, and I found that they are written in English language. I even intended to reproduce the content of the documents, but to avoid being wordy, I'll just refer to the date of the documents. Exhibit AA N33 is a WhatsApp chat dated 3rd December 2014, while Exhibit 33 is an internal memo dated 7th May 2007, and are written in the language of the court, contrary to the assertion of the defendant. Maybe the defendant counsel wanted to refer to a different document. For Exhibit 14 and the other computer-generated evidence, CW1 in the course of her testimony has given oral evidence that satisfies the requirement of Section 84 of the Evidence Act. See the case of Silva and Dixon. For Exhibit 13 and 36, it's an evidence that the claimant has given the defendant a notice to produce, but it failed to produce. And it is tried that the principle that guides admissibility of documents is relevance. If the document or evidence is relevant to a fact in issue and legally admissible, it will be admitted in evidence. The probative value to be attached to such document is something else. See Section 6, 8, and 10 of the Evidence Act. See also the case of Akinao and Ayodele. Let me quickly point out that by the provision of Section 12 of the National Industrial Court Act, this court, even though is bound by the provision of the Evidence Act, but can depart from it in the interest of justice. In the circumstance, therefore, I have no hesitation in overruling the objection raised by the defendants on the admissibility of some of the claimant's document in the interest of justice, and I so do. Accordingly, Exhibit 12, 13, 14, 33, 35, and 36 and 37 remain admissible in evidence. For the substantive case, it is the grievance of the claimant that her summary dismissal on account of the allegation raised against her by the defendant is wrongful, as she was not afforded fair hearing and the disciplinary committee was improperly constituted in violation of the defendant's conditions of service. However, the defendant contended otherwise. In resolving this issue, let me refer to the defendant's staff condition of service, Exhibit 25, 24, and NICA 2. According to the defendant's report of the disciplinary committee and the letter of dismissal, the claimant was dismissed on account of absence from duty without leave, which is provided under Section 4.4.2.3 of Exhibit NICA 2 under the categories of serious misconduct. Section 4.4.2.3 provides thus, and I quote, absence from duty without leave. Any officer who is absent from duty without authority renders himself liable to be dismissed from the service, and the onus shall rest on him to show that circumstances do not justify the imposition of the full penalty on court. When by the staff conditions of service, there are some laid-down procedures that must be followed before dismissal of an employee on ground of misconduct or serious misconduct. Section 4.5, 4.6, 4.7, and 4.7.1 provide as follows. Disciplinary committee. There should be a central disciplinary committee comprising representatives of all the directorates, representatives, the legal department, and representatives of the unions to which the affected staff belong. The industrial relations unit shall serve as the secretary of the committee. All recommendations made by the committee shall be submitted to the management through DFA for consideration. Disciplinary proceedings in accordance with this regulation shall be initiated on the ground of misconduct or an employee's general incompetence or inefficiency. A standing disciplinary committee, as indicated in Section 4.5, shall be established for quick dispensation of disciplinary cases in the authority. The guidelines shall be as follows. A, following a report of misconduct by an employee, the head of department shall give a verbal warning to the employee depending on the gravity of the offense committed. However, in relation to serious misconduct, the head of department shall request the director in charge of human resources to handle the case, and the human resources department shall issue a written query to the hiring staff. B, where after reviewing the response of the employee, the human resources department determines that the misconduct or offense merit more than a warning, the matter shall be referred to the appropriate disciplinary committee for consideration. Where a case is referred to the disciplinary committee, the recommendation of the committee shall be submitted to the DG through the DFA for final approval. For general guidance, it needs to be pointed out that in all disciplinary matters, reference must be made to the DFA to ascertain the fact and other professional advice recommending or determining appropriate disciplinary action in order to maintain a measure of uniformity. The Director of Finance and Administration could, where necessary, act in liaison with the legal department, especially concerning matters of criminal nature. Disciplinary procedures as defined should be strictly followed at all times. Disciplinary measures. In the event of any infringement of the rules or regulations by the employee or any misconduct, the authority has the right to impose the following measures as considered appropriate to the gravity of the offense. Warning: an employee who commits a minor offense or shortcoming in the performance of his duties shall be warned verbally by his head of department. Employee whose conduct or work is unsatisfactory shall be given a query in writing by his head of department. The presentation of the employee and the comments of his head of department shall be forwarded to DFA for final assessment. After 3 written warnings in a year, the case will be referred to the appropriate committee for further disciplinary action. In all cases, the alleged fault of an employee will be brought to his notice through the issuance of a query. Any query issued to an employee must be dealt with and returned to the responsible officer within 48 hours from the period of receipt of such memo. Unquote. Let me quickly here refer to the contention of the learned counsel for the claimant, that the claimant must have been issued warnings before his dismissal, that the claimant was never issued one. Counsel rely on section 4.2.3 of Exhibit NICA 2, which provides as follows: removal for general inefficiency. Before the proceeding for the removal of an officer for general inefficiency may be commenced, he must have been warned on 3 occasions in writing. Unquote. However, the above section only talks about removal of an employee on ground of his inefficient performance, but not on ground of his misconduct, as in the instance case. The argument is thus misconceived. Now, the law is that where an employer dismissed or terminated the appointment of an employee on grounds of misconduct or any infraction, all that the employer needs to establish to justify his action is to show that the allegation was disclosed to the employee, that he was given a fair hearing. That is to say that the rules of natural justice were not breached, and the disciplinary panel followed the laid down procedure, if any. See the case of University of Calabar and ASEAN. It needs to be recalled that the most important aspect in disciplinary hearing is that it must be conducted fairly according to the rules. To be able to do this, the employer is entitled to know the nature. The employer is entitled to know the nature of his the charge against him in order to be able to prepare for his case. He should also be given the opportunity to state his case no matter what the circumstances are. It's not essential that he should be present in person throughout the hearing. See the case of Inweto and UCTH. And once an employee was confronted with such allegations of misconduct or infraction before his termination, he cannot complain about a lack of hearing. Exhibit NICA 2 is a binding agreement between the parties. And when the parties voluntarily enter into a written agreement, they are legally bound to honor its terms. Therefore, the relationship and subsequent dispute are governed by the agreement and must be resolved according to the agreement, though the court cannot impose terms outside of what the parties agreed on. It was said in the case of Ahmed and CBN that parties are bound by the terms of their contract, and the court cannot read on such contract what was not within the contemplation of the parties, except where fraud, duress, or misrepresentation can be established. It is instructive to add that the terms of the contract between the parties have significant weight, are considered sacred. And when interpreting a contract, the written terms The primary guide and the cost role is to interpret the contract, not to write it. See the case of Minaj Holdings Limited and Amcon. The court, therefore, in determining whether there has been a breach of that contract, are enjoined to confine themselves to the plain words and the meaning derived from the document. See the case of Oyamandi and Abraman. It is evident from exhibits NICA 7 and AN 52 that the claimant was issued queries. That the claimant was issued queries which she answered in exhibits NICA 4 and NICA 8. It was also shown that she was invited to a disciplinary committee by exhibit 19 and 21, which she attended and made representation, even though she contended that the disciplinary committee was improperly constituted. The report of the disciplinary committee is contained in exhibit NICA 13. Once an employee was confronted with allegations of misconduct or infraction before his appointment is terminated, he cannot complain about lack of fair hearing. So once an employee was confronted with allegations of misconduct or infraction before his employment was terminated, cannot complain about lack of fair hearing. See the case of Joseph and Fast Ilambang. I wish to state that the claimant was issued two queries. First one dated 27th November 2014 and signed by the General Manager of Finance. And the second one dated 9th of December 2014 was signed on behalf of the GMHR. Was signed on behalf of GMHR. But it can be observed that the content of the two queries with regards to the absence of the claimant from work centers around her absence from duty from 18th of November 2014 to 26th of November 2014. Even though it was abided by the defendant in paragraph 41 of the statement of defense that the claimant absented herself from duty without leave from 18th November 2014 to 26th of January 2015, and also averred in paragraph 3 that the claimant had no approval for 2014 annual leave and her trip to Israel, but there's no query issued to the claimant by the defendant with regards to alleged abandonment of duty post and absence from duty without leave approval from 27th of November 2014, 26th of January 2015. The two queries are with regards to absence from work from 18th November 2014, 27th of November 2014. In any case, one thing that agitates my mind is that the claimant wrote and submitted her application for the filing of her 2013 annual leave on the 11th of November 2014 to take effect on the 18th of November 2014. But the defendant declined the request of the claimant on the 26th of November 2014 and immediately issued her with a query the following day for being absent from work, for being absent without leave. It is stated in the query that the claimant was absent from work without permission from 19th of November 2014 to 27th of November 2014 when the query was issued. I observe that it's minuted by the Director of Finance and Accounts on the claimant's application for leave that the General Manager of Finance should communicate the decision declining the request to the claimant. But it appears that there's no such communication to the claimant. Let me refer to what the DW1 said under cross-examination. And I quote, Yet the claimant was granted an annual leave from 1st November 2013 to 30 November 2013. The claimant did not observe the said leave granted to her because the leave expired. By Exhibit 9, the claimant requested for the deferred 2013 annual leave, but it was declined. Exhibit 9 was dated 11th of November 2014, and the leave was commenced on the 18th of November 2014. However, the minutes on the application were between 25th November 2014 and 26th November 2014. I don't know whether the claimant was notified that a request for the deferred 2013 annual leave was declined. Yes, the claimant was issued a query on the 27th of November 2014 on court. Following from the above, I suspect that the conduct of the defendant in keeping the claimant's letter for more than 2 weeks before it was finally acted upon leaves much to be desired. Even though it is clear that the claimant did not observe her 2013 annual leave, and inasmuch as the claimant was not supposed to proceed on her leave until her request was approved, the defendant at the same time is not also supposed to keep the claimant's letter with ease without treatment until 26th of November 2014 and still query the claimant for not coming to work during the pendency of her application. I do not think that sounds fair and reasonable, and I so find and hold. I think the claimant should be given the benefit of the doubt as a staff who has worked for the defendant for 14 years and has been honored in recognition of her selfless service, dedication, and stellar performance. Defendant cited Section 10.2 of Exhibit NICA 2, and contended that leave is forfeited once it is not observed within the year. Section 10.2 provides as follows: leave will be granted annually to employees of the authority for vacation and may be taken anytime between January and December, according to the department leave roster. All employees must take and exhaust their vacation leave within the calendar year in which such leave is earned, and any period of vacation leave which is not exhausted shall be regarded as forfeited. Considering, however, that the maximum leave entitlement is in a year is 30 calendar days, all staff should have exhausted their leave entitlement of a calendar year before 1st February of the following year. Management may, with the consent of an employee, commence or defer the leave, but it should not be for more than 1 year. However, it is the law that in the interpretation of statutes or documents which restrict the student's right, any doubt, gap, duplicity, or ambiguity as to the meaning of words used in the enactment should be resolved in favor of the person who would be liable to the penalty or the deprivation of his right. See the case of Nigerian Army and Lampard. See also the case of Onwansu and Imo State Environmental Sanitation Authority. For the claimant's contention that the disciplinary committee was not properly constituted, I see nothing wrong when a joint action committee is put in place to represent all the unions in the defendant institution, especially that the claimant in the instance case has not been able to establish any miscarriage of justice that caused injustice to her with regards to the alleged vacuum in the composition of the disciplinary committee. For the claimant's claim of January and February 2015 salary on her alleged abandonment of duty post, claimant alleged that withholding of her salary amounts to double punishment. But I have a different view on that, considering the fact that it is clearly provided in Section 10.12 of the handbook that an employee who fails to resume duty without reasonable excuse shall be regarded as absent from duty without authority and shall forfeit his salary for the period of absence, and in addition shall be subjected to appropriate disciplinary action. However, it is my view that since the claimant was not formally queried and disciplined by the defendant on her alleged abandonment of duty post and absence from work from 18th November 2014 to 26th of January 2015, and on proceeding to go for her 2014 leave without approval, then the claimant is entitled to a withheld salary. The claimant was only given query for absence from work from 18th of November 2014 to 26th of November 2014. The claimant has also claimed for reinstatement on the basis that employment is protected by statute. I wish to say that employment is still to be laced with a true label where same is created by statute and regulated by terms and conditions of service. See Council of Enugu University of Technology and UDE, Chitabe and Federal Civil Service Commission. I therefore find that the defendant is established I therefore find that the defendant is established by Section 4 of the Civil Aviation Act 2022, and its conditions of service that apply to all its employees have the force of law, and they invest the claimant a legal status beyond the ordinary or mere master and servant relationship. Consequently, claimant's employment is protected by statute. All said, I'm of the opinion that claimant's case succeed, and I therefore make the following declaration and orders. Number one, a declaration that the claimant's employment enjoys statutory level. Number two, a declaration that the summary dismissal of the claimant was unlawful and ought to be set aside. Number three, an order setting aside the summary dismissal of the claimant by the defendant. Number four, an order reinstating the claimant to the service of the defendant. Number five, an order directing the defendant to pay the claimant forthwith all the arrears of her salaries and other entitlements from 27th of August 2015 to date of judgment. Number six, an order directing the defendant to pay the claimant forthwith the sum of 666,000 naira, being the claimant's salary for January and February 2015, which was withheld by the defendant. Judgment is entered accordingly with no order as to cost.
Hey, please, my lord.
Thank you.
My lord, we are very grateful for the well-considered judgments.
Thank you, Mr.
Most of my lord.
Thank you. Yes, Mr. Chief. You are muted. Unmute yourself.
Yeah, my lord.
Chief.
My lord. Yes, I said we are most grateful for the well-considered judgment, which we regard as a very good Christmas present to the claimant. And we thank His Lordship for the incisive judgment once more.
It's Mr. Obianwu's sister. She's his sister, so I think he's going to. But anyway, in any event, I don't know whether he's going to appeal. But I know she's his sister.
Yes. It is. I know we have interacted before. They are related.
I can't hear you, Mr. Obi. I can't hear you. You are muted.
I said we'll test it. Not necessarily appealing, but we'll test it. Yes, sir, so that we can learn.
Regardless of the fact that she's your sister.
Yes, my lord.
Okay.
We'll test it so that the others coming before us can learn.
Okay, yes. We will learn too. When it gets there, we'll see how.
Yes, Lord. But every issue was properly considered and determined.
Okay.
Yes, my lord. We really appreciate the judgments.
Thank
you.
One
or two places we feel.
Yes.
We feel aggrieved. We feel aggrieved. Yes, my lord.
Okay. So I would love to hear the outcome of the appeal when.
Yes, my lord. We'll do that tasting, my lord.
Okay, it's okay.
Yes, it's okay. Thank you very much for the well-considered judgment.
Mr. Chukuma. I appreciate all of you.
Thank you, my lord.
I've also learned a lot. I've learned a lot, yes.
Yeah.
I've learned a lot, yes. Mr. Chief Paul, thank you so much.
Yeah. Yes,
my regards to everybody and wishing you happy New Year in advance.
Amen. Thank you, my Lord.
Thank you so much.
Thank you, my Lord.
The judgment, when do we expect to have the copy?
They will be sent. I'm going to sign them today and leave the file and the copies of judgment with the registrar here. So he's going to send them to Lagos, God willing.
Yes, okay. Thank you, my Lord.
Thank you so much. Thank you.
Okay.
Okay,
Thank you, my
bye-bye.
Lord. We are very
Thank you,
grateful.
Mr. Chukuma. You fall. Thank
My
you.
sister, you don't want to greet me.
Is she here?
I
My
think
sister,
maybe
good afternoon.
she joined later. She appeared to have joined subsequently. Yeah.
Yes.
Second.
Senior, thank you very much.
Yes, thank you.
Okay, sir. Have a nice day.